Hello U.S. History students, and welcome to Unit 8, Lesson 2, Important Supreme Court Cases of the Civil Rights Movement. In Unit 8, Lesson 1, we talked about Plessy v. Ferguson from 1896 that established the separate but equal clause and really creates a justification for segregation throughout the United States well into the 20th century. This case established those racial segregation practices as being okay. It's not until 1954 that Plessy v. Ferguson is changed. And it's changed with the Brown v. Board of Education in 1954. And this leads to the success of the civil rights movement. The case itself overturns or reverses Plessy v. Ferguson, saying that separate but equal is not okay, and we need to change it. In this case, the NAACP says that segregated schools deny equal protection under the 14th Amendment because, well, they're really not equal. The attorney that's arguing this case is an attorney for the NAACP named Thurgood Marshall. And he is a very prominent guy who believes in the rights of African Americans and of all people, really. He tries to desegregate the school system, and he fights to say that segregated schools are inferior or not as good. And he later becomes an associate justice on the Supreme Court. Some very important points from Brown v. Board that you need to understand is that Brown v. Board says segregation is an unequal form of education. And it really shows that by saying if one group of people has a nice, well-kept building, it's clean, the desks are good, the textbooks are updated, like in the top picture, but the bottom picture you've got a bunch of kids crowded into a room that doesn't even really look like a classroom. It's dirty. Your textbooks are out of date. That is in no way an equal education. And it's not fair that one race should get a better education than another. And it shows that society is slow to change. Because despite the Supreme Court saying you must desegregate schools, it takes years for schools all over the country to integrate or come together. Most of this is in the South, where Jim Crow laws are very, very strong. But it takes years for these schools to finally say, okay, we will do this. And there were some schools even in the 21st century that were still separate. But the main thing is this case says separate educational facilities are unconstitutional. They violate people's rights. And this is the springboard to the modern civil rights movement. The effects of this case is that many states delay desegregating schools. For one reason or another, well, we don't have the facilities, or we don't this, or we don't that. They made up excuses. One of the very most famous of these is Arkansas Governor Orval Faubus. He is an anti-civil rights person. He favors segregation. He really believes that, well, the races don't need to be mixing. And he didn't want the schools in Little Rock, Arkansas, or anywhere in his state to integrate. We also see something called the Southern Manifesto. And this is where members of the Senate and the House released a resolution opposing desegregation. So these are elected officials in the Senate and the House of Representatives that are openly disagreeing with the Supreme Court's ruling. And this manifesto urges the states to resist integration of the schools. So this is really the government in one branch completely disregarding what the government in another branch has to say. So more in depth on Orval Faubus, he was the governor of Arkansas from 1955 to 67, and he is very pro-segregation. He doesn't believe the races should mix. And he really challenges the authority of the government to desegregate schools, because he basically thinks that he should get the say because he's the governor of Arkansas and he should be able to determine what happens in his state because, well, the federal government's just not here. He shows the refusal of the government to integrate public schools, specifically in the capital of Little Rock, and ordered the National Guard to surround Little Rock Central High School and not allow African American students inside. And this leads us to the Little Rock crisis. All white schools in Little Rock were the standard. Segregation reigned, and Governor Orval Faubus stood at the door of Little Rock Central High School with the National Guard supporting him when 9 African American students tried to go to school there, and he refused to let those kids into the building. He literally stood at the door and said, "You're not coming in here." Not only that, but the students were aggressively threatened by angry mobs of white students, screaming at them, throwing things at them, and just in general being really, really hateful to them. And the significance of Little Rock is that it shows that the federal government would enforce court decisions, because Eisenhower, who was president at the time, deploys the 101st Airborne Division to ensure that those students had safe passage to class. And those soldiers stayed with them and protected them throughout the school day to make sure that nobody bothered them. And President Eisenhower exercises his federal authority to enforce a ruling to desegregate public schools and says, "I'm not letting this happen on my watch." The next important case is Sweat versus Painter, and this is a Texas case where an African American student, Mr. Sweat, wanted to attend the University of Texas Law School. But when he did his application, they denied him based on the fact that he was black. And in this case, they actually delay the ruling for 6 months, I believe it was, to create a separate law school to say, okay, well, here you go. Here's a law school you can go to. It's all African American. It's fine. However, the NAACP fights this, and they fight it on the grounds that, okay, great, you made a new school, but that school's not equal to the University of Texas. Because in the University of Texas Law School, as you go through the program, you make connections with people, you network, you make friends that are going to help you in your career as a lawyer. And that separate law school that was created did not have those same connections and did not offer him the same opportunities as UT would. And in this case, they win. The NAACP wins, and he gets to go to UT. The next case is Delgado versus Bastrop. And this is another Texas case that says that Mexican Americans who were in segregated schools was unconstitutional. Because just like with Brown versus Board of Education, Mexican Americans were in segregated schools from the white kids, and their schools were dirty, they were not well kept, their facilities were not good, their textbooks were not good, they didn't have the same resources. And just like in Brown versus Board, the court rules that this violates the 14th Amendment to equal protection under the Constitution because these kids while being Mexican American, are still kids, and therefore they deserve the same rights as the white kids. And they basically said separation based on national origin, just like separation by race, is illegal. And this forces the integration of Texas schools, just like Brown versus Board of Education forces integration of all schools. Another very important one for us to know is Miranda versus Arizona. In this case, a gentleman by the name of Miranda was arrested, but he didn't understand what rights he had and ended up saying things that could have been used against him and were used against him. And he ended up being convicted of this crime. And in this case, the Supreme Court ruled that detained criminals must be read their constitutional rights. These are your Miranda rights now, is what we call them. You have the right to remain silent. Anything you say can and will be used against you in a court of law, blah, blah, blah. Basically what the cop has to say to you if you're being arrested. This protects your Fifth Amendment right to not have to testify against yourself or say anything that's going to incriminate you or could be used against you in your trial. The next one is Hernandez v. Texas. Hernandez was indicted for murder. So essentially he's on trial for murder. He's a Hispanic man. And under the Constitution, every citizen has a right to a trial by a jury of their peers. This is a Sixth Amendment right. In his case, however, Mexican Americans were not allowed to participate in juries. So he was a Mexican American man being put on trial, and the people that were hearing his trial were all white. He ended up being convicted. And in this situation, the case rules in favor of the 14th Amendment, saying that Mexican Americans could not be excluded from participating in juries under the 6th Amendment. That he had to have the right to have people like him hearing his case. Not just a bunch of white guys. He needed other Mexican Americans hearing his case so that he could get a fair trial. Next, we have Wisconsin versus Yoder. This case is pretty unique because it comes down to freedom of religion. The situation was that an Amish family, Amish being a type of religion, a stricter version of Christianity, so to speak, believed that their kids did not have to go to school after the 8th grade. Because essentially this wasn't going to teach them anything that they needed to know past that grade level, and they could, not need it for their Amish way of life. And what they needed to learn at that age to be a proper member of Amish society. And they were the state was trying to force the family to make their kids go to high school. And the family saying, no, this goes against my religion. I think my kid has learned all they need to learn. They don't need to know the stuff from high school to be able to be a proper Amish person. And in this case, the court rules that the court ruling prohibited states from claiming the absolute right to compel school attendance beyond the 8th grade or to intrude on how families are to raise their children, because that was violating their First Amendment right to freedom of religion. The last one we're going to look at is a case called Edgewood versus Kirby. And it's similar to Brown versus Board and Delgado versus Bastrop in that it's a situation where one group's school is in worse shape than the other. But in this case, it is Kirby ISD, which is a poor district with a very large Mexican-American population. And money was not equally distributed to that school district. So their buildings were not as well kept. They didn't have as much money for materials and resources as nearby richer school districts. And the court ruled that this violates the 14th Amendment and led to the decision to redistribute the property taxes from wealthy school districts to poorer ones so that facilities could be better maintained in all districts, as opposed to only the districts that had the richer families and the better neighborhoods. John F. Kennedy's Executive Order 10925 was for equal employment opportunity, and JFK is very, very prominent in the civil rights movement. Unfortunately, he doesn't have a lot of time to be able to create more civil rights opportunities. But this executive order creates laws against discrimination in the workplace and promotes more fair employment practices. So you can't be an African American who goes to get a job and they can't say, no, I'm not hiring you just based on your race because of this equal opportunity employment clause. And the Equal Employment Opportunity Commission is a federal agency that enforces workplace equal treatment. Everybody's human, everybody gets treated the same. It also investigates discrimination cases based on race, religion, gender, sexual orientation, and things of that nature. And this is something that he signed in 1961. Voting rights are very heavily contested throughout much of American history on who should have the right to vote. And it starts out with just rich, landowning white men. And eventually, as we move more into the modern era, we see more and more different people getting the right to vote. The 15th Amendment allows African American men to vote. The 17th Amendment allows direct election of senators, which expands the voting process because now, instead of those people being appointed, they're voted on by people who are in their area, in their state, and they're held accountable by those people. If they don't do what those people feel is right, they won't be elected again. And so this allows more direct opportunity for voters to voice their opinions and have a say. The 19th Amendment is women's suffrage, which means women now have the right to vote as of 1920. And the 26th Amendment comes about in the Vietnam era when you had to be 21 years old to vote, but you could be 18 to be drafted and fight in the war. And many of these soldiers who had been drafted felt as though that was really discriminatory against them. If I'm old enough to fight, and you think I'm old enough to be sent over here to this war, why should I not be old enough to vote for my elected officials? And so this amendment is passed during that era. With many of the restrictions that we talked about in Lesson 1 lifted, the number of African Americans registered to vote greatly increases. Just to give you an example of how much this changed, in 1964, only 6% of African Americans voted in the elections. 5 years later, in 1969, that rose to 59% of African Americans. That's a huge jump in just 5 years. Not only that, but they started to run and be elected to public office, including the first ever African American Congresswoman, Shirley Chisholm. So not only was she the first African American Congresswoman, but this sets a precedent for future women of all colors and all races and all religions to say, I have this opportunity. I can run for office. I can make a change. This brings us to the end of Unit 8, Lesson 2, and I hope you have a great day.